Welcome back to This Week in Immigration. I'm Jordan LaPier. On this week's program, a supersized edition of the Gavel. We dive into the latest on immigration policy in the federal courts. Stick around. Here with me today, as always, are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown. Hey, Theresa.
Hi, Jordan.
And Chris Ramón is here. He's a Senior Immigration Policy Analyst on Twitter at CRamonBPC. Hi, Chris.
Hey, Jordan.
All right, thanks to you both for being here, as always. So, as I said in the intro, we're spending our episode today checking in on immigration policy in the courts. A hallmark of the last 3.5 years has been ongoing legal challenges to many of the Trump administration's immigration efforts, and the last several weeks have been notably busy on that front. So for each of these cases, we're going to look at the broader context, what the various courts and judges said in their rulings, and the practical impacts of those rulings. So let's start our swing around the courts at the Ninth Circuit Court of Appeals in San Francisco, which just ruled in favor of the Trump administration in its efforts to eliminate temporary protective status for those from El Salvador, Haiti, Nicaragua, and Sudan. And that decision overturned a lower court injunction halting the end of TPS for these countries. So, Chris, I'll kick it to you first. What's the context for this case?
So basically what happened is that, President Trump, when he entered in office was looking and there were a lot of reports as to whether or not he was going to eliminate or extend temporary protected status for a range of communities, particularly, for instance, Haitians and Salvadorans. The president finally ended up going through with this decision approximately 2 years ago. And what he did is he just ended the program. And this is a pretty significant thing because the program is essentially sort of a temporary status for individuals who are in the United States and can't return back home because of an armed conflict, an environmental disaster, or some other extraordinary and temporary condition. And the U.S. government can renew that whenever this TPS status expires. And for a lot of these communities that had been renewed, through the years across different presidential administrations, but the Trump administration decided to end that. So this would have been, this was a major decision because a lot of these individuals have lived here in this country for an extremely long period of time, work in the country, some of them have U.S. citizen spouses or U.S. citizen children. And so they've been here for a long time. So the decision was pretty impactful for this. And there was a series of litigation against this decision that yielded a preliminary injunction. But of course, what happened is that the administration appealed that, and that's what brought us to the current point to this decision.
Theresa, walk me through what the court said in its ruling here.
Sure. So as Chris indicated, there had been preliminary national injunctions by lower district courts against the moves to terminate TPS for El Salvador, Haiti, Nicaragua, and Sudan, as well as Nepal and Honduras. This was a Ninth Circuit Court of Appeals. The government had appealed the preliminary injunction that the lower court had issued, and the government appealed to the Ninth Circuit. In a 2-1 decision, the Ninth Circuit overturned the preliminary injunction, stating that the administration could terminate TPS for El Salvador, Haiti, Nicaragua, and Sudan. Now, there's a separate case in New York for Haitians that still has a separate national injunction that would protect Haitians for now, but the other countries, El Salvador, Haiti, and Nicaragua, would be impacted by this decision by the Ninth Circuit. This Ninth Circuit decision said that the underlying court erred in granting the preliminary injunction, primarily because the statutory language for TPS actually precludes courts from reviewing decisions to grant status or terminate status for a country. And there had not been sufficient evidence provided that there was, for example, direct animus against these countries, particularly racial animus based on statements of the president that impacted the decision of the DHS secretary to terminate these statuses. So on those grounds, it overturned the underlying court injunction. Now, there's actually two different court cases that were combined. This decision was for El Salvador, Haiti, Nicaragua, and Sudan, but a separate court that was looking at the cases for the Nepalese and Hondurans said that they would base their case decision on what happened in the Ninth Circuit, so they could also be affected by this.
Cris, how many TPS holders will be affected by this? And as Theresa was sort of leading into, what are the impacts of this ruling, the potential impacts?
So in terms of overall numbers, when this decision came out, people were saying it's approximately 300,000 individuals will be affected from these countries. So first of all, the number is not insignificant. That's quite a bit of individuals who are in the foreign-born population. But I think the bigger story is just how integrated these individuals are in the United States. For instance, when you're looking at where they work, a lot of them tend to work in the construction industry, in restaurant, food services, and landscaping. So they're pretty integrated into local economies, kind of filling in labor gaps for mid to low skilled jobs, but ones that are still very much needed. The other thing to really consider too is that, these individuals, have U.S. born children. A 2017 study of TPS recipients from the Center for Migration Studies said, there are approximately 273,000 U.S. citizen children who were born in the United States for TPS beneficiaries. And about 10% of Salvadoran TPS recipients, 9% of Haitian recipients, and 6% of Honduran TPS recipients are married to a legal resident. But the most important thing is that a lot of these TPS recipients have lived in the United States for about 20 years or more. So when you're looking at the totality of this, you're seeing that this could potentially be a pretty negative impact for some local economies. Obviously, for families that can be, this can definitely uproot them and can be very just disruptive for the lives of for these individuals and their families that they've built here for so long. So the decision is definitely going to be impacting a lot of individuals, and I think that this is going to raise questions as to is there a better way of doing humanitarian protections for these populations that may not fall necessarily under our asylum and refugee categories, but certainly aren't able to return to their countries? How can you provide them with a long-term protection? And I think that's where the conversation needs to go on the policy front.
The only thing I would add is that USCIS previously said, since these cases were pending, that they would wait at least 120 days after any final court order before revoking TPS for any groups. They also have a bilateral agreement with El Salvador stating that they will not remove any or take TPS away from Salvadorans until November 2021. So for just in terms of logistically, most of these groups, again, pending any subsequent appeals, would continue to maintain status until early next year at the earliest. Which does punt this issue until until after the election. And former Vice President Biden has stated that if he is elected, he would extend TPS for this group and seek legislation to grant them status. There have been bills introduced in Congress and a bill that passed the House that would grant permanent status to these TPS holders, but it has not moved past the House. So it's definitely a question that will become part now of the electoral season.
All right, let's turn now to another issue that's big in the electoral season and will wrap up before the election, and that's the census. Whether and how to count unauthorized immigrants has been a source of contention during the 2020 census. Earlier this month, New York's Southern District Court blocked implementation of a July 2020 memo from President Trump excluding unauthorized immigrants from the census count and thereby limiting their impact on congressional apportionment. This is the second time the administration has lost in court on the issue after the Supreme Court struck down its efforts to add a citizenship question to the census. Cris, what's the context here?
So what happened is in February 2018, the administration announced they would add a question to the U.S. Census asking about an individual's legal status, whether or not they were a U.S. citizen. And this then generated a lawsuit to, counter that. And this eventually led up to the Supreme Court, which the Supreme Court stated that the administration didn't follow the proper procedures for adding the question without really addressing the underlying legal question of whether they could or could not. But that happened last year, and so that was a pretty major loss for the administration. And some observers were thinking, well, the administrations probably won't do that much on this front, and they would just sort of retreat from that until this summer, when the president issued the executive memo arguing that we need to not count undocumented immigrants in the census. And that led to another series of lawsuits, and that what brings us to this. So this has been a pretty long-running issue with the administration and the courts. So it's interesting to see, once again, that the administration is losing on this issue after trying to do this again.
Theresa, over to you. What did the court say in its ruling on this issue?
Sure. So this ruling came out of the district court in the Southern District of New York. It was a 3-judge panel of 2 Republicans and 1 Democrat. And the case was filed by the state of New York and 22 other states, plus the District of Columbia, 15 cities and counties, and the U.S. Conference of Mayors. There was a separate case filed by a coalition of non-governmental organizations that was consolidated with it. And the plaintiffs in this case asked the court for summary judgment or a preliminary injunction. Now, summary judgment basically means we think that this is a clear-cut case of violation of the law, that we don't need to have arguments or hearings, just based on the filings that were made and the straight statements that are not in dispute. We think the court can rule immediately on this case. And that is exactly what the court did. The court issued summary judgment in favor of the plaintiffs. And what this means is that the plaintiffs made such a strong case that the administration had violated the plain language of the statute, that the court ruled in their favor. And this is kind of the strongest decision a court can make. It says basically that this is flat out wrong and you can't do it. The court said that the memorandum that the president wrote violates the statute governing the census in several ways. First, it says that the statute requires the Commerce Department to present only one set of numbers for apportionment to the president. And the presidential memo said that they should present 2, the total number of people and the number of people not counting undocumented immigrants. So in that case, it violated the statute. The memorandum also stated that it was the policy of the United States to not count undocumented immigrants in the census apportionment numbers. And the court said that that actually runs counter to the explicit statutory scheme, which requires the president to use the same single set of numbers that's required for apportionment. They said the memorandum violated the statute because it claimed that undocumented immigrants could not be considered residents of the states they were residing in, and that violated the plain language of the statute, that they are considered persons residing in the states. So they ordered that the Commerce Secretary not include estimates of the undocumented population in the report to the president. There were other constitutional claims raised by the plaintiffs. Of course, the census is mandated under the Constitution. The court didn't reach those constitutional claims because they saw that the memorandum clearly violated the Census Act. And under the rules of jurisprudence, courts try to avoid looking at constitutional questions if they can rule on different parts of the law. Importantly, the court did say that they had authority to rule on the case right now, even though nothing had happened yet under the memorandum, because the plaintiffs, they said, made a substantial case that just having this out there was already impacting the responses to the census, and that in turn could impact them in many different ways. Many of the same arguments for standing under the citizenship question case that went to the Supreme Court. So this is a pretty strong decision. We haven't yet heard if the administration intends to appeal this decision, but it's a pretty strong decision against the Trump administration.
So what's your read then, Theresa, on what this means for this year's census itself and for congressional apportionment that gets underway next year after the count is complete?
Well, I think at this point, it probably puts a nail in the coffin of any further attempts of this administration to try to do something about it. There are still some outstanding cases about the length of time for the census. The census is usually supposed to wrap up in October. The Census Bureau indicated that they wanted to end the in-person counting, so where they send people out to neighborhoods to try to count the people that had not previously sent in their census form. They wanted to cut that off a month early at the end of September. There's been some court cases that have ordered them to keep that going until the end of October to try to ensure that we have sufficient responses. The initial responses from the Census Bureau seem to indicate that there is lower response rates, or has been lower response rates this year. That's not surprising, in part due to COVID. People may not be where they usually reside in this period of lockdowns and quarantines, and all of the concern about whether or not undocumented citizens or non-citizens should be counted and how has created undercounts in certain areas that have high immigrant populations. So a lot of people who are really concerned about making sure everybody gets counted doesn't want to see that stopped. But in terms of the administration pushing to change the apportionment rules, obviously they may appeal this decision to a higher court. The higher court could set aside this summary judgment and order the lower court to reconsider the case or consider the case in a different way. That may not necessarily allow the administration to go forward, but it would overturn the underlying decision. But we're in such short time frame now before the election, I don't think anything is going to happen of this before then.
Okay, after the break, challenges to the suspension of legal immigration and the latest in a series of suits related to the treatment of immigrant children. Stick around. And we're back. This month also saw more challenges to the administration's recent efforts to suspend legal immigration to the United States, which it says were undertaken to protect jobs during the recession and pandemic. This month, the U.S. District Court in D.C. ruled that the administration cannot legally ban visa issuance, but the ruling only ordered the government to resume processing diversity visas for now, leaving open the questions surrounding other immigrant and non-immigrant visas. Cris, what's the context here?
So after the coronavirus pandemic began, taking its toll on the U.S. economy, the Trump administration announced a series of bans on immigrant and non-immigrant visas for individuals living overseas, to primarily for them to come and work in the United States. So in particular, you had the employment-based green card category of individuals who are going to come and work in the United States on a permanent basis. And you also had non-immigrant categories such as the H-1B high-skilled visa. The administration suspended the processing of those visas from overseas, and argued that these steps would protect jobs for American workers. So, not surprisingly, the bans were challenged. In particular, you saw particularly the private sector and a lot of trade organizations coming in and actually suing because they just felt that the moves, which were done under 212F authority, which is essentially in the Immigration Nationality Act, that gives wide berth for the president to be able to suspend the entry of non-citizens. They challenged that. Basically, the idea that the president did that really wasn't aligned with what he could actually do under that authority. So basically, it was just a response to the administration really trying to limit the entry of individuals, which our own research that I looked at is a little bit questionable since most of the job losses have been in fairly mid to low skilled jobs in the hospitality and restaurant sector, where a lot of these individuals don't work. So I think that that's sort of a little bit of the context to understand where these lawsuits came from and where this decision came from.
Theresa, walk me through what the court said in this ruling.
Sure. So as Cris noted, the proclamations that were issued in April and June of this year suspended the entry of immigrants in many categories, including the employment-based categories, family-based categories, and the diversity visa. And then the June proclamation also suspended the entry of non-immigrants. It's important that I use the word entry here, although Cris talked about visas, and that's an important consideration in what the court ruled in this case. Section of the immigration law that the president has used for these and other entry bans is 212F, and that uses the specific term entry, that the president can suspend entry of any foreign nationals for particular reasons. This court case revolved around the issue of whether or not barring entry also meant suspending issuance of visas. And why that's important, particularly for the diversity lottery winners, is that people who were selected to receive a diversity visa only have until September 30th of the year in which they win to actually receive their immigrant visa, or they're no longer eligible. Now, they could enter after that date as long as they receive their visa before that date. And so that's where the court ruled. The court issued a preliminary injunctive relief order that ordered the State Department to immediately begin processing these DV visas for people who had won. And they have to be processed by the end of September. The court found that that was the group most likely to have the most harm from this suspension of entry, and the State Department's interpretation of the presidential memo that barring entry also meant barring issuance of visas. But the court ordered them to proceed. He said there were two different things, and that they should proceed with all alacrity to process those DV visas. The rest of the court case for employment-based immigrants, family-based immigrants, and non-immigrants continues to this day. But what's interesting is that the court ruling in this particular preliminary relief order that issuance of visas is separate from barring entry could mean that more people would be eligible to get a visa. In our immigration system, a visa does not guarantee you admission to the United States. A visa is like a ticket to try to enter. So it allows you to travel to the United States, but whether or not you're allowed to enter is determined in a separate adjudication at the border by a border officer. Usually you have to have a visa to show up and appear, but just because you have the visa is no guarantee that you can be admitted. Different grounds of inadmissibility may be found at port of entry that may not have been available or known at the time you got the visa, or other things in the intervening time period could come up, such as a international pandemic. So the point being that the court basically said that the State Department's decision to not issue visas based on an entry ban was arbitrary and capricious, and that they needed to immediately move to issue these diversity visas.
So I'd like to put this question to both of you, but Theresa, I'll start with you. How will this ruling impact that broader immigrant and non-immigrant visa ban the administration put in place earlier this year?
Shortly before this ruling came out, the State Department had issued some guidance on what constituted exceptions to the non-immigrant visa ban, and those exceptions were pretty broad. So already we're seeing and hearing that there are more non-immigrants who are being admitted under those national interest exemptions. So I think that there's already a bit of a turning. Clearly, the State Department is going to have to look at whether or not it should just resume visa issuance generally, and that these entry bars would be based on, whether this proclamation is still in place at the time somebody enters the United States. Even though the DV visa holders had an absolute deadline, there is still a time limitation on other visa categories. In general, if you're eligible for an immigrant visa and you don't obtain that visa and enter within a certain period of time after you're eligible to get one, you can be considered to have abandoned your application. Now, there may be arguments as to why that time should be extended, and they can certainly do that. But if it's an employment-based visa, perhaps the company no longer needs the worker. Family-based visas could be jeopardized over time if a family member dies. So there are other considerations to this delay that could harm other people without the absolute deadline that, for example, the DV people had. And I think that, obviously the government may very well appeal this ruling. But for the time being, the State Department is moving to process these DV cases, and I think we're going to see some additional arguments going forward for the other classes as well.
I think the thing to add also is that there is another legal challenge in the Northern District of California, and this might actually, I think, be more substantial. what we might see there is a ruling, or at least an exploration of what kind of authority you can use for 212F authority, or the justifications, particularly ones that are driven by domestic economic considerations. So if it's the case that the Ninth Circuit kind of actually says 212F authority doesn't really apply to thinking about domestic economic considerations as a national security justification or foreign policy justification, you actually might see these bans potentially skating on very thin ice, given that 212F authority is the reason why they're being cited. So there could be potentially a much broader broadside against the bans coming down the pike from the Northern District of California. But until then, we, like Theresa said, I think we are seeing the administration trying to sort of retreat a little bit on the hardline positions they took on some of these suspensions. So we just need to see where the courts are and whether that will prompt the administration to start taking some even further retreats on these policies moving forward.
Finally today, we look at the cases surrounding treatment of immigrant children in government custody. This month, Judge Dali G., who oversees the Flores settlement, an agreement that regulates treatment of immigrant children, ruled that the government could not detain these children in hotels. You'll recall a few episodes ago we discussed the media reports of children being housed in several Hampton Inn hotels in Texas and Arizona. Immigration advocates challenged the practice, which DHS has used to keep children in its custody while processing them under what's called the Title 42 program, which expels migrants from the border on public health grounds. Cris, walk me through the context.
All right. So, we did talk about this a few weeks ago, but to catch up folks who didn't listen to that episode, basically this spring, the Trump administration introduced a policy under healthcare law, under a healthcare pretext, that said that individuals who arrive at the U.S.-Mexico border can be expelled, and that's a term of art, can be expelled from the United States, given the fact that the United States needs to protect the public health of its population. That was the underlying justification, and the process is actually a pretty quick return process. Individuals reportedly were being returned back to Mexico somewhere in the ballpark of 96 minutes. But what started happening, though, is that there were stories that emerged this summer of children who were not being expelled immediately under the Title 42 program, and that these children were being held in hotels instead of official government custody locations in the United States. They were being held in hotels until they could be expelled. And once this story broke, I think people were beginning to criticize this because they believed that the Trump administration was trying to evade oversight for these individuals. So there was a series of lawsuits filed to ensure that these children could be covered under the Flores settlement. And the Flores settlement is a settlement that's been in effect for a very long time, but it is essentially a settlement that regulates the treatment and conditions of non-citizen children in government custody, as they're being processed through the removals. And so it has some pretty strict guidelines on what can happen. But the one key thing really is that, the advocates wanted to ensure that the children could be covered by this and that the children receive the protections afforded by the settlement. So that's kind of the context for this development, for this decision.
Theresa, tell me a little bit more about what Judge G said in her ruling.
So she basically said in the ruling that hotels are not adequately safe and do not sufficiently account for the vulnerability of unaccompanied minors in detention. That's an actual quote from her order. And she ordered CBP and ICE to stop holding migrants in hotels and release unaccompanied children to Health and Human Services by September 15th. She also said that the ruling applied to families who have minor children as well, that they could not be housed in hotels. There was an exception, a small exception made for minors who are only held 1 to 2 days while awaiting transit. But in general, all of them are to be remitted back to Health and Human Services. The court order was appealed by the government. The government went to the Ninth Circuit asking for an emergency stay of that order. That was argued before the Ninth Circuit just this week as we were recording this. And there was some testimony from the government that showed how prevalent this was. The government admitted that they had expelled more than 8,800 children without any U.S. process under the Title 42 orders. A total of 159,000 people have been expelled under the order since March, including more than 7,600 individuals in family units. Now, they said the most of them were returned to Mexico, but at least 2,200 unaccompanied children and 600 people in families were held in hotels until they could be deported to other countries. This was part of the government's statements to the court, admitting how many people had been this had been done to. We do not have, again, as the date of this recording, a decision from that Ninth Circuit on whether there's going to be an emergency stay of the judge's order. But we have also heard reports that over the last month or so, CBP is turning more unaccompanied children over to HHS. So apparently they are on their own shifting how they handle these children.
Cris, let me start with you here. How will this decision impact the Title 42 program?
This is really significant. As Theresa noted, we're seeing CBP kind of starting to retreat and handing these unaccompanied kids, these children, over to HHS. But I think the bigger story here is that it's starting to bring in a lot more accountability and oversight to the treatment of individuals that are being processed through this program. I think the fact that, you started hearing these stories of children being held in locations that normally are not locations that would be used for holding, child migrants, definitely raised questions about whether or not this is really the best way to provide oversight over the program. So I think the key thing that's going to come out of this is that there might be significantly more oversight over the treatment of individuals that are being expelled, but can't be expelled immediately to Mexico. So that, I think, that's the big takeaway, that there's going to be significantly more accountability, or hopefully there will be more accountability over, the treatment of individuals that are being expelled. Now, does this mean the program is going to end? No, this decision was very narrow in what it was focusing on. But at the very least, like I said, there is more transparency and accountability for the treatment of child migrants as they're being moved through this process.
Theresa, your thoughts here?
No, I agree with Cris. The Flores settlement has been in the news as much or more in the last 3 or 4 years than it has been any time since the settlement was put in place during the Clinton administration. I mean, it is the fact that this is a long-term settlement that affects how the government can treat children in custody. And this is one of those areas that, I'm reminded that the one time the president affirmatively turned back on his own from a policy that had been implemented in the administration was the zero tolerance policy that separated children from parents. The American public is very reluctant and very conscious of how we treat immigrant children, and does not believe that we should treat them in poor ways. And things like this are the one sort of thing that causes a lot of public concern, and the government is responding to that. Sometimes because the court is ordering it, sometimes because of public pressure. But it's an ongoing issue. As long as children continue to arrive at the border, they're going to have to find better ways to deal with it.
All right, Theresa, Cris, that's a good place to leave it for today. That is our show. Thanks to you all for listening. We will be back in 2 weeks. Before we go, a quick reminder, subscribe, rate, and review this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or your favorite platform. You can also find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. This Week in Immigration was created by Theresa Cardinal Brown and myself. The executive producer of This Week in Immigration is Theresa Cardinal Brown. This week's episode was written by Cris Ramón and myself. Our producers are Cris Ramón and Yafet Tawahada, and our editor is Yafet Tawahada. The executive producer of BPC Podcasts is Ashley Swearingen. I'm Jordan LaPier. Join us again next time on This Week in Immigration.